So good.
Good evening to all of you. Today's discussion is on the Hindu Succession Act of 1956. First of all, before going to the act, you must know the definition of the word Hindu. Which are all the communities which come within the definition of the word Hindu? As far as Hindus are concerned, it's a wide definition. Hindus mean Hindus normally, then Parsis, then you've got what is called the Buddhists, then you got the Jains, Agarwals, so on and so forth. They come within the definition of the word Hindu. Of course, if you look into the dictionary, the word Hindu is not defined anywhere. Even in the law lexicon, the word Hindu is not properly defined. It only, I think, in a loose meaning or loose connotation, you can only understand it as a way of life as far as a particular community is concerned, or what they call it as the Sanatana Dharma, which is followed mostly by Hindus, irrespective of whichever community they belong. But here, Hindu Succession Act was passed in the year 1956. As far as the Hindu Succession Act of 1956 is concerned, it contains nearly about 29 to 30 sections. Here, you need not go through all the sections, please. Here, only the important sections are the purport of the Hindu Succession Act, the revolutionary changes that were brought about by the Hindu Succession Act, how women are given equal rights, how gender justice is followed as far as the Hindu Succession Act is concerned, the long fight of women as far as their rights are concerned, how it was addressed by the Hindu Succession Act of 1956 is very, very important. Here, before we go into the subject, we'll have to know that the Hindu Succession Act applies to all Hindus, that is, Hindus, Jains, Agarwals, Parsis, and so on and so forth. But here, one important thing is that women are given more rights as far as the Hindu Succession Act of 1956 is concerned. Before 1956, Hindu woman especially was treated as a third rate citizen. Why? Because she can enjoy the property so long as she is alive. And she cannot alienate the property, she cannot encumber the property, she cannot sell the property, she cannot mortgage the property, she cannot give the property. Why? Because if she has heirs, no problems. But if she has no heirs, then in that case, the son of the last male holder, that is her brother-in-law's son, that is her husband's brother's son, has got a preferential right to succeed to the property after her demise. And woman had only limited rights, and she can enjoy the property so long as she is alive, and after her lifetime the property has to go to the brother's son, or what is called the nearest male heir, that is the husband's brother's son. So these people who are the husband's brother's son, those days they were called as reversioners. 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 Reversioners mean the son of the last male holder, and if the wife has no children, then in that case the property has to go to the reversioner. And under no circumstances this Hindu widow can alienate the property, sell the property, encumber the property, or deal with the property in any manner. She is permitted alienation only under two circumstances. That is, one is to discharge the debts of her deceased husband, number one, or to meet a pressing legal necessity. Unless these two conditions are prevalent, a Hindu woman prior to the Hindu Succession Act of 1956 was not entitled to alienate the property. And what estate devolves on her after the demise of her husband is only a limited interest, or what is called a life interest, and she can alienate it only under two circumstances: to press a legal necessity, or to discharge the debts of her husband, or to maintain her body and soul together. Only under those two circumstances she can alienate. But in case she alienates, irrespective of the restriction imposed, the reversioner, that is the son of the last male holder, that is her husband's brother's son, as soon as he becomes entitled to the property after the demise of the lady, then he can bring a suit to set aside the alienation by saying it is not actuated with legal necessity, or it is not, alienation is not for the benefit of discharging the debts of her husband. So the alienations in most of the cases were set aside. So that is why it is said there's a proverb also which I coined. It's to say the Damocles sword of a reversioner hangs precariously on the noose of a hapless widow. That is, the brother's son, no doubt, is entitled to succeed as a reversioner, but the woman who is in distress, she is not being maintained. But he wants the property, but he doesn't want to maintain that woman, a poor, hapless Hindu widow. So that is the reason the Damocles sword always hangs precariously on the noose of a hapless widow, and the reversioner at any time after the death of the lady can bring a suit to set aside the alienation. Then this led to a lot of outcry among the women. They, what they did was they agitated by saying that we are also equal citizens, we are also equally entitled, we are also human beings, we, our rights also has to be recognized, and this restriction of imposing a reversioner on the noose of a widow has to be abolished. Then this led to the lot of discussion in the parliament, and the union government felt it necessary to pass an act called the Hindu Succession Act of 1956. That's how the Hindu Succession Act of 1956 came into existence. And as far as the woman's estate is concerned, now it is not a limited estate at all. It is only a life. It is not even what is called Sharia. The life estates have been abolished, and women have got equal rights as far as men are concerned. So these are, and one more thing, and there was a doctrine called doctrine of survivorship. Doctrine of survivorship means if the property vests with two, let us say, two persons are the sharers, that is the brothers, that one of the brother expires, then one brother is only alive. Under the doctrine of survivorship, it is said whoever survives gets the entire property irrespective of the share ratio which is possible, which is provided. Now, of course, after the 1956 enactment, the doctrine of survivorship also has been abolished. So now it goes purely by succession. Then we got one more thing. Most of the women are joyous. That is in where what happened was when in our state, I'm talking about in Telangana, or those days composite Andhra state, when the celluloid hero NTR came to power, he amended Section 8 and introduced a section called 8A. Please remember, as far as self-acquired property, or what is called in Telugu as swarjitam is concerned, women get equal shares as far as the males are concerned. But as far as a coparcenary property is concerned, woman has no right as far as coparcenary property is concerned. And here, ancestral property is concerned, she is not a sharer and she is not entitled for any share. But NTR brought about a revolutionary change in the Hindu Succession Act. He introduced a section called Section 8A by saying that equality to women was granted all women married after 28th February 1985. Please underline the word all women married after 28 to 1985 are entitled to a share, equal share, even in the ancestral property. That is what Section 8A was concerned. 8A was brought about by the amendment of Section 8, where 8A was introduced, coming into effect from 28 February 1985, to say that any woman who is married after 28th February 1985 has an equal share along with her brothers. So even the right to share in the coparcenary property was recognized by the amendment or introduction of Section 8A. Then the Union government did not keep quiet, and in 2005 they brought the Amending Act, whereby they introduced a new section called Section 29A. Here, uh, as far as amendment is concerned, it says that a female child by birth gets a vested right in respect of even coparcenary property, and she is entitled for an equal share along with her brothers, and her rights cannot be defeated by any act. Right? And even they went to the extent of saying that even if the partition has taken place amongst the brothers and the sister's share is ignored, then in that case, sister can always bring a suit for asking for her share as far as the coparcenary property is concerned. So, for all practical purposes, 29A has brought about a revolutionary change as far as women's rights are concerned, whereby a female here also gets an equal share in respect of coparcenary property. Then, sir, another drastic change that was brought about was introduction of Section 14. I'm only giving the introduction. I'll come to sections in the proper perspective. Section 14 says that as far if the property stands in the name of the woman and the sale deed or the documents of title are in the name of the woman, you cannot say that she has got only limited interest and it stands nominally in the name of the woman and and it has to go by succession. Here, Section 14 has brought about a major change whereby there they say that any property that stands in the name of a woman is not a limited estate or it is not a life estate. She is deemed to be the owner as far as the property is concerned. No person on earth can defeat her rights. She can alienate the property, she can give the property, she can encumber the property, she can deal with the property in any manner as full owner. That is what Section 14 says. One more section that underwent an amendment is introduction of Section 6. Section 6 says after the passing of the amendment, that is in 2005 by the central government, whereby Section 29A was introduced and Section 6 also was introduced, whereby they say devolution of property as far as coparcenary is concerned, females get equal share as males. And this was one of the revolutionary steps that was taken, recognizing the rights of women. Then, sir, you have got class 1, class 2, class 3. That's what Section 8 postulates. Section 8, who is class 1, who is class 2, who is class 3, has been defined or stated in Section 15. Then, these are all the. Then one thing, when 29A was introduced, there was satisfaction among women, which encouraged them to demand more rights. Today, I think most of you know that women are demanding 33.5% reservation even in legislatures and parliament. They say gender justice is to be maintained. Even in the judiciary, if you see today, 90% of the judges who are appointed as JCJs, or what you call junior civil judges, are ladies. That is the reason the importance of ladies has been recognized. They are also treated on par with the males, and there is no discrimination as far as women are concerned. And many laws have come which come to the rescue of a woman. For example, after the 1956 Act, you've got the Dowry Prohibition Act, which I discussed yesterday. Dowry Prohibition Act of 1961 was also introduced, whereby a woman's rights are also protected if she is if there is a demand for dowry and there is harassment as far as dowry is concerned. Whatever amount is paid towards the dowry, including marriage presentations, ornaments, and so on and so forth, the woman is entitled to get it back under the provisions of Section 4 and Section 6 of the Dowry Prohibition Act. Then you've got so many rights that are conceded, and today women are treated on par with males. So this is the brief introduction as far as the Hindu Succession Act is concerned. But first and foremost is మనకు సబ్జెక్ట్ తెలిసే ముందు we'll have to go to the Onamalu. Onamalu means the alphabets of the section, alphabets of the act. First definition that is given is the agnates and agnates means related by blood on or adoption through males. Agnates Agnates means related by blood. Related by blood. Agnates means related by blood or adoption through males. Agnates means that is the father's side. That is how they are related, how they are born of the same blood, whether they are born of the same father, and whether they are adopted by the same father. They are called agnates. But as far as cognates are concerned, it is said they are cognates means who are not wholly through males. Even cognates means even from the mother's side, if any legal heads are there, they are called cognates. When agnates are there, cognates are normally neglected. Normally, cognates do not come into picture. But if agnates are not available, there is a legal heir through the husband, either by adoption or by any other means. And through the husband's side, they are called agnates. And as far as cognates are concerned, the legal heirs from the mother's side are called cognates. Then the next definition that is given is custom. Custom is, what do you exactly mean by custom? Custom means a usage or a particular right which is exercised by people from times immemorial and followed without any interruption, and it is called a custom. And sometimes, customs override the law. For example, there are different kinds of marriages in different communities, and custom recognizes it. And many people have got married according to that particular usage or a particular system. Then they are called custom. And if this custom is narrated by many people, it gets the sanction of law or the power of law. And the next definition that is given is that is uh, full blood, half blood, and uterine blood. That is descended from common ancestor for but different wives. That is common ancestor. That is Tatagar, but different wives. Sometimes, if a wife doesn't have children, a person marries a second time, but they owe their origin to their common ancestor. But they are born of different wives, then they are called, though of the same father, it is called full blood. But here, as far as half blood is concerned, they are born to different fathers but same mother. That is what is called, the mother is the same, but this lady has undergone multiple marriages. But the children who are born out of that wedlock with the other husbands, they are called half blood. Full blood means born to the same father but to different wives. But half blood means born to the same woman but by through different husbands. They are called half blood. Then what is called uterine blood? What do you mean by uterine blood? Uterine blood means born of the same uterus of a woman but born to different fathers. They are called uterine blood. These are the various definitions that are laid down in section 3. Then we go to section 3. Then we go to section 5. What do you mean by intestate succession? Intestate, intestate, intestate succession. Intestate, what do you mean by testate succession and intestate succession? Testate succession means which is through a will, which is through a legacy, which is a bequest through a will. It is called a testate succession. Intestate succession means where there is no will, where there should be devolution of property, how the property has to devolve, how it has to be distributed, who gets what share and all. It is called intestate succession. Here, section 5 says that that is any estate descends to the any estate descends to a single heir by the terms of any covenant entered into with the ruler of the state before the commencement of the act. So, any covenant, any stipulation, any condition before the Hindu Succession Act came into force, what were the regulations? What was the agreement? What was the understanding? Then the property devolves according to. I'm talking about prior to the enactment, please. Then next is Stridhana. What do you mean by Stridhana? As far as Stridhana is concerned, it is divided into two parts. One is called Sri and another is called Dhana. Sri means lady, Dhana means her wealth. So whatever representations are made by her father at the time of marriage, whatever she gets from her father's side after getting married, and whatever is given to her in contemplation of marriage by her parents is called Stridhana. As far as Stridhana is concerned, is the absolute owner of the property of the woman, and she can dispose of in any manner she likes, and married daughter is excluded. Married daughter is excluded. Here, as far as Stridhana is concerned, it is the absolute property of the woman. She can do anything with the property she likes. She can alienate the property, she can gift the property, she can sell the property, she can encumber the property, or do whatever she wants. And she is deemed to be the full owner of the property. But as far as Section 5 is concerned, married women are excluded as far as succeeding to the property of Stridhan. Now, normally, sir, the defenses that are normally taken by a woman in a litigation is she says that all the properties are purchased by me out of the Sridhan given to me by my parents. It does not belong to my husband. So, of course, those things will have to be alleged and proved also. But if the property stands in the name of the woman, she is supposed to be the full owner of the property. Husband has no right to claim any right over the property. He cannot question the ownership of his wife, but he can allege. There is one act which we are not going to discuss now, which says that the husband says, it is not Sridhan, sir, it is my own property. I funded the purchase, I paid the consideration, I raised funds, and so on and so forth. Then there is an enactment called Benami Transfers Prohibition of Alienation Act of 1968 or so, where they say the husband has to prove and establish that the property stands normally in the name of his wife, but he is the absolute owner. Then, sir, the question is the next section is 6. Section 6 is devolution of property or interest in coparcenary. A daughter by birth entitled to coparcenary rights prior by that is by success survey, but not now established only by devolution during she gets equal shares. Here, as far as Section 6 is concerned, the position prior to the Hindu Succession Act was concerned, it was said that a daughter is entitled to a share only by survivorship. Suppose the deceased, suppose let us say the deceased had only two daughters, or let us say one daughter and one son. Let us say the son expires. Under the doctrine of survivorship, the daughter gets the full share. That was the position prior to the Succession Act. But after the Succession Act came into force, woman is entitled to full rights, and that's how the amendment has been brought about as far as Section 6 is concerned. Here, a gift by coparcenary to another without without any other coparcener is void. That is, a gift by a coparcenary to another without the consent. Here, suppose let us say 2 or 3 coparceners are there. 2 or 3 people are entitled for a share in the property. One of the coparcener transfers the property by way of a gift to another brother who is also a coparcener. The brother who is deprived, that is the third brother, can always question it by saying his consent was not obtained and therefore this say gift is void. And this is the judgment rendered by the Supreme Court, AER 1967. Kindly note down, sir. AER 1967, Supreme Court 1775. Here it said, give by a copartner to another without another's consent is void. So AR 1967 Supreme Court 1775 says, when there are 3 or 4 copartners and one of the copartners gives his share to the other copartner, then in that case, the 2 other copartners who are there whose consent has not been taken, the gift fails because consent is absolutely necessary before you transfer the property to another copartner. Then we go to the most important section in the Hindu Succession Act called devolution of property. There are 3 classes of people who are recognized, sir. Class 1, Class 2, Class 3. Here, order of succession is stated. Class 1, who are the Class 1, sir? Son, daughter, widow, son, daughter, widow, mother, son of a predeceased son, daughter of a predeceased daughter, daughter of a predeceased daughter, widow, son of a predeceased, suppose a widow of the predeceased son of the predeceased Predeceased means who dies earlier. Father, the predeceased son. So, who are the class 1 heirs? Son, daughter, son's son, daughter's son, daughter, daughter's son, predeceased son's daughter, predeceased daughter's daughter, predeceased daughter's uh, predeceased daughter's son, so on and so forth. These people are called class 1 heirs. They get the first preference as far as the sharing ratio is concerned. Are you able to understand, please? All of them get equal shares. Then class 2 people are, that is what is called father, son's daughter, brother's sister, daughter's son's son, that is grandson, daughter's daughter, that is the granddaughter, brothers, then brother's daughter, then brother's son, brother's daughter, sister's daughter, father's father, that is grandfather and grandmother, then father's widow. Father's widow means your grandmother, and brother's widow, that is your brother's wife. Then father's brother. Father's brother is your uncle. Then father's sister, that is your aunt. Then mother's father, that is your mother's side, your maternal grandfather, maternal grandmother, and then your mother's mother, grandmother also gets a right. Then mother's brother. Mother's brother is your menamama. Then mother's sister. All these people come under class 2. When does class 2 come into operation, sir? Class 2 comes into operation when class 1 is not available. When class 1 is available means I have given you son, daughter, son's son, daughter's son, daughter's daughter, son's daughter, predeceased son's daughter, predeceased son's widow, predeceased son's daughter, then so on and so forth. And even the mother comes under class 1 heirs. If these people are available, then class 2 doesn't come into play. Class 2 అంటే కొద్ది దూర రిలేషన్షిప్ అనమాట. They are all called the class 2, that is father comes under the class 2, then the son's daughter comes under class 2, son's daughter's daughter comes under class 2, sister comes under class 2, then daughter's son's son, daughter's son's daughter, so on and so forth. These people come into operation only when class 1 is not available. If class 1 is available, they get the preferential right, and as far as males are concerned, females are concerned, they get equal shares. Are you able to understand, please? Then we go to section 10. How the distribution is made. First is the widow of the deceased, sons and daughters and mother, then heirs of the branch of such predeceased sons and or daughter, then equal shares. So first son, next daughter, then mother, then son's son, son's daughter, daughter's son, daughter's daughter, and then they all get equal shares, and the property has to be distributed equally amongst them if it's an intestate succession. Then, sir, agnates and cognates. But as far as agnates and cognates are concerned, they are dealt with by section 12, which says first preference is normally given to agnates. Agnates means born of the same father, but where the adoption takes place, devolution takes place of the same father, but the adoption is done by the father, that is by male. But as far as cognates are concerned, born of the same father, but of different wives, they are called cognates. As far as agnates and cognates are concerned, cognates do not get any share during the presence of the agnates. Then, sir, as far as section 12 is concerned, class 2 also get equal shares. Then section 13, that is computation of degrees can be computed. Every generation constitutes a degree. How the degrees has to be constituted, sir? Petatata, Chinatata, so on and so forth. That's how the generation, that is PD is a PD. That's what and a Purvikul, my grandfather, brother, brothers, so on and so forth. They are one generation. So it devolves according to the personal laws. Then, sir, women's property. This is the most important change that has been brought about by the Hindu Succession Act. Prior to the Hindu Succession Act coming into force, women were treated inferior to men. And please remember, in Hindus, they say a woman has no right to live apart from her husband. And here, as far as woman is concerned, she only had limited rights. She had only and she cannot alienate the property, she cannot sell the property, she cannot encumber the property, and she can enjoy the property so long as she is alive. Only a life interest is devolves on her, and and please remember, after her death, if she has no issues, the property goes to the reversioner, that is the son of the last male holder. She can alienate the property only under two circumstances. One is legal necessity, and another is for discharging the debts of her deceased husband, and the third one is to maintain herself in life. And if even if one of the ingredients are not present, the reversioner, after the death of the widow, can bring a suit to set aside the alienation that has taken place by the widow in favor of a third party. And in all those cases, alienation used to be set aside. Then please remember, it led to a lot of outcry among women to say that we are no way inferior to males. We should be treated on par with the males. And therefore, the Hindu Succession Act of 1956 brought out a drastic amendment whereby they say any property that stands in the name of a female, it is her absolute property. She can do anything with the property. She can sell the property. She can give the property. She can encumber the property, and no power on earth can dispute her right. So whatever estate devolves upon a Hindu widow or a lady is her absolute estate, and it is her own property, and it cannot be questioned. It cannot be challenged in any court. In other words, the institution of reversioners was abolished. Then we go to uh, section uh, section 40. In order of succession in case of females. Here, section 15 says sons and daughters, that is, disclosed children, heirs of the husband, mother and father, heirs of the father, in the absence of anything to the heirs. Here it said, as far as section 15 is concerned, first is goes to the sons and daughters, sons a son, sons a daughter, daughters a son, daughter's daughter, and next one is for mother and father also get a right, and heirs of the husband. Heirs of the husband is our brother-in-law children also, and then heirs of the father. Heirs of the father means his other sons. Then in the absence, according to the heirs, the property has to devolve. So please remember, one cardinal rule is once class 1 heirs are available, class 2 doesn't come. Only when class 1 is not available, class 2 comes into the picture. Then section 19 is two heirs take a tenants in common and as joint tenants. Suppose two legal heirs are there, two sons are there. What is their position, sir? They take it as tenants in common. They have equal rights over the property. One has got 50%, another has got 50%. Equal rights devolve upon them under the provisions of section 19. Then section 20 deals with child avant samer. That is, suppose, let us say, the child is in the womb of the mother, then the child, as soon as it is conceived, it also gets the same rights as per the rights of devolution. Then 21 is presumption as to simultaneous death. Then here, suppose, let us say, whether the father has died first or the mother has died first, then whoever is younger in age or under this, perhaps the section 21 may not apply now. Section 21 applied when survivorship was there. When survivorship was there, the question is, two brothers are there. One of the brother expires, the other surviving brother gets the entire estate. Then suppose both of them die at the same age, then at same time, then how it has to be devolved, sir? The younger person is supposed to die later, and the elder person dies earlier. So in that case, the property goes to the heirs of the younger son. Then right of preemption, section 22 is right of preemption. Right of preemption is, suppose there are four legal heirs, then one of the legal, that the suppose the property has to be sold outside. Please remember, before it is sold outside, the next heir will be given the right of choosing, right of purchasing, and he has got the preferential right to purchase the rights of the other person who wants to sell it. And this right is recognized under section 21. It is called, I'm sorry, section 23, section 21, it says right of preemption. Then section 22 deals with right of That 22 we can kindly omit, sir. Right of preemption in business. Suppose one of the sharer wants to go away, and let us say he wants to transfer his share to some outsider. But before he does it, he must offer it to the next sharer and give him an option to purchase his share, and only then he can give it to an outsider. That is what Section 22 deals with. Then the most important Section 23, earlier, as it was laid down before the Hindu Succession Act, was that as far as a dwelling house is concerned, as far as a residential house is concerned, as far as a building is concerned, woman was not considered as a co-partner, and she was not entitled to a right of residence as far as the property is concerned. But by the Amending Act of 2005, Section 23, or the Amending Act as well as the old Act, the Amending Act of Section 23 now abolishes Section 23. 23 is no longer available in the statute book. Then Section 24, you can omit this. Section 24 is omitted. Section 20 24 are omitted by the Act 39 of 2005. Then 25 deals with murder or disqualified. Suppose a person in the family has been convicted of murder and he has committed multiple murders. He is in the jail. He has undergone jail sentence. He is disqualified from getting any share in the property. That is what 25 says. Then 26 says converts. Converts means suppose you are a Hindu, you get converted into a Muslim, or you get converted into Christianity, then you lose your right of succession as far as Section 26 is concerned. Then before intestate shall devolve on the died earlier. Here, as far as 27 is concerned, it also deals with what is called survival. Any person dies before intestate, it shall devolve as if he died testate. That is, suppose let us say a person dies intestate. That's what Section 27 says. Here it says that suppose a person dies before the intestate succession, it shall devolve as if his shares will not be removed. His shares will remain intact, but his legal heirs will take the property. That is what Section 27 says. If a person, then Section 28 says, you cannot say, sir, a person is suffering from disease, or a person is suffering from a virulent disease, or a person is suffering from communicable disease, or he has been keeping indifferent health. That is not a disqualification as far as succession is concerned. Disease or not, no disease, it is not a disqualification under Section 28. Then succession by survivorship, again I repeat, has been abolished. We don't have survivorship now. Then we go to the most important section where women's rights are recognized. A revolutionary change has been brought about in the lives of a female as far as coparcenary property is concerned. By the Amending Act of 39 of 2005, women women's rights as far as ancestral property is also recognized. They are also equally entitled to the estate. They are also equally entitled as the brother as far as the share is concerned. So Section 29A has removed the anomaly as far as the female is concerned regarding ancestral property. I could say one thing, sir, that as a practitioner with so many years of standing, only the son-in-law comes to me to draft a notice asking for a share. The girl is not interested. She says, my father has performed my marriage in a lavish scale. He has given everything and he has nothing to give. He says, Are property ఇస్తున్నాడు కదా నీ అన్నలకు వీళ్ళకంతా నువ్వు కూడా పోయి అడుగు. Then the question is notice is issued. The Pandora's box of dowry death sometimes is opened because of this amendment. But the aim and the object of 29A being introduced was to say that females' rights are also recognized. They are also treated as equals with males, and they get equal rights as far as ancestral property is also concerned. They are treated as what is called equal. Also, one of the legal heirs entitled to the as far as self-acquired property is concerned, they already come under the class 1 heirs. But as far as coparcenary property is concerned, ancestral property is concerned, they get equal shares like our brothers. And that's why 29A is worded in such a form to say that as soon as the rights of a female by birth is recognized, and the interest which she devolves is vested, and she can enjoy the property equally along with her brothers, and she is also entitled to a share as far as ancestral property is concerned. So, either to the anomaly which was there, there is discrimination which was there, as far as females are concerned, in respect of coparcenary property, has now been removed, and this section 29A has to be read in conjunction with section 6A, 6 of the Hindu Succession Act, which says a female child, as soon as it is conceived and as soon as it comes into existence in this world, gets a vested right, an equal right, along with her brothers in respect of even coparcenary property, and she is recognized as one of the legal heirs entitled to equal rights. And this aspect, the question is, there is a leading case. I think that is the latest case on what is called on female rights. That is the leading case of Vinita Sharma versus Rakesh Sharma. That is 2009. Please note down, please. Vinita Sharma versus Rakesh Sharma. That is 2020, bracket 9, SCC. That is Supreme Court cases, page 1. It is a full bench judgment where the Supreme Court has asked to decide the applicability of 29A. The question that arose before the Supreme Court was whether the act is retrospective or whether the act is prospective. The court, while deciding it, said the purport of section 29A, the object of section 29A, or the purpose for which 29A is introduced is to recognize the rights of the female heirs. And they said as soon as a female child is born, she gets a vested right as far as the property is concerned, and she is entitled to an equal share with the brothers as far as the ancestral or coparcenary property is concerned. And the Supreme Court was also asked to decide whether the act is prospective, that is from the day of the amendment or even before that. The Supreme Court in its wisdom held that the act is also retrospective as well as prospective. That means it applies even prior to the amendment and even after the amendment. So that was the leading case of Vinita Sharma versus Rakesh Sharma, reported in 2029 Supreme Court cases, page 1. Here. Here, in one of the cases before the Supreme Court, that is a case of Kamla, KAMLA space Neti, NETI versus Kamla Neti versus LAO, Land Acquisition Officer. It is reported in 2023. 3 SCC 528. Here the question that arose is whether a tribal woman belonging to the Northeast or any other Adivasis, whether they are female especially, whether they are entitled to a share in the ancestral property. Here, the Honorable Supreme Court interpreted it by saying that tribal women cannot be deprived of their equal rights as far as the coparcenary property is concerned. They are also entitled to equal shares. Then, sir, the question arises, sir, what is the limitation period for bringing a suit for partition, even if you take 29A into consideration? Like recovery of immovable property, or for bringing a suit to recover immovable property, as you said, there is 12 years period. In the same way as for to bring the suit for partition, as far as a woman is concerned or males are concerned, the 12 years period is mentioned. Within 12 years, you must bring a suit for partition. Then, sir, here another judgment, sir, Arunachala, ARUNACHALA, Arunachala Gounder, GOUNDER, Arunachala Gounder versus Ponuswamy, PONNUSWAMY. Arunachala Gaundar versus Ponuswamy. Their judgment is reported in 2022 bracket 11 SCC 520. 2022 11 SCC 520. Here, in this case, they said a property acquired, even if your father acquires a property through partition, or he gets the property through a family partition, or from his grandfather, father, or so on and so forth, even in that property, the question is females get a right. So, in other words, to summarize, the Hindu Succession Act, it has brought about revolutionary changes as far as the rights of women are concerned, as far as the interstate succession is concerned, and they have also brought about a change as far as the plight of women is concerned. The Honorable Supreme Court in Vinita Sharma's case has said the act is both prospective as well as retrospective, and female's share cannot be removed. And by birth, she gets a vested right in respect to the property. And Section 6, read in conjunction with 29A, says the property vests with the woman also, and she also gets an equal right. And the question is, she also forms part and parcel of the Coparcenary. And Section 23, where it was as it was originally laid down, where it says a woman is not entitled to a share in the dwelling house, that has been omitted. And now the question is, even a woman is entitled to a share in the dwelling house. These are the various changes that have been brought about by the Hindu Succession Act of 1956, whereby mostly the importance is given to class 1, class 2, class 3. Class 1, you've got a variety of people. Then first, when class 1 is available, class 2 doesn't come into the picture. Class 2 comes into the picture only when class 1 is not there. So these are all the things which has been dealt with the Hindu Succession Act. And the applicability of the Hindu Succession Act, it applies to Hindus, it applies to Buddhists, it applies to Sikhs, it applies to Jains, it applies to Agarwals also. So the word Hindu is a very wide connotation that is given. And most of you are aware of the Khalistan movement also. Article 25 defines a Sikh also as a Hindu. And please remember the Khalistan movement, they said the word, the question Sikh should be removed from the caption of Hindus. Of course, that didn't succeed. That's a different matter. So, the doctrine of survivorship has been now abolished. The question is, suppose there are two heirs and one of the legal heirs dies, the other legal heir gets the absolute right. But now that has gone, it has to go by succession. So, women have got, please remember, the more emphasis has to be given to 29A and Section 6, where they say woman by birth gets an absolute right and an equal share in the Coparcenary property also. And she is also a legal heir who can claim equal share along with her brothers. And Vinita Sharma's case, the Supreme Court has categorically held that the amendment of Section 29A is both retrospective and prospective. That means, what do you mean by prospective? Applicable only from the day of amendment. But the Supreme Court interpreted it by saying, even prior to the amendment, it applies and a woman's rights cannot be taken away. Then women's estates, which was only limited before the passing of the Hindu Succession Act, and the institution of reversioners, that is the son of the last male holder who is entitled to succeed to the property if the woman had no legal heirs, then that has now been abolished, whereby they say woman's estate is an absolute estate as far as Section 14 of the Hindu Succession Act is concerned. This is the purport of Hindu Succession Act of 1956. So please remember the important sections, sir. The definitions: agnates means, that is, agnates is defined as the that is, it is said, means related by blood or adoption through males. Related by blood or adoption through males. Cognates means related by blood but through females. Then next one is custom. Custom means a usage which is prevalent in a particular community for a very long time. It is called custom. Then we define what is meant by full blood, half blood, and uterine blood. Full blood means born of the same generation and to the same wife. Half blood means born of the same father but of different wives. Uterine children means children were born of the same uterus but of different fathers. Then the question is, we have also discussed how the interstate succession takes place, how it is divided, how we have got class 1, class 2, class 3, also class 3 is vagera vagera. But the question is, how women's rights are there and what are the changes brought about as far as the emancipation of women is concerned by the introduction of, by the amendment of Section 6 and read in conjunction with Section 29A. These are all the sections which we have to keep in mind while discussing the Hindu succession. Any questions, please?
Iyengar, please go ahead, sir.
Good evening, sir.
Good evening.
Sir, even though the property is partitioned, the daughter is entitled for the...
Yes, even now it's that even a partition also the share doesn't go anywhere, but the suit has to be brought within 12 years.
It is even after 2005, sir.
Yes, sir.
Okay. Thank you.
Okay.
Any questions?
Yes, sir. In case of this Stridhana and Binami issue, the class 1 legal heads, they don't have any proof in case that the husband paid the consideration. And then how, sir? Do they need to prove it that...
See, that is as far as it is a suit that should be brought by the husband against the wife, because under Section 3 of the Benami Properties Transfer of Benami Properties Prohibition Act, the Section 3 says the husband has to prove his income, where from he raised the money, how he raised the money, how he paid the money, how he is paying the EMIs, so on and so forth, and what is the earning capacity of the wife.
Sir, yes. But now in case both the husband and wife died, and now the case is fighting by the legal heads,
yes,
and they don't have any proofs, either side, Stridhana side or Binami side.
If they don't have any proof, it goes by general law. That is the law of succession applies according to class 1 or class 2, whatever it is.
Okay. Thank you, sir.
Right.
Any more questions?
And can you suggest any commentary for this Hindu Succession Act, sir?
Hindu Succession Act, many books are there, sir. I could say there is a composite Hindu code. If you can, just 1 minute, book page, sir. Or just a minute, sir.
We'll give you
you can contact my admin. He'll give it to you on your phone, sir.
Okay, sir.
Yeah.
Thank you.
Any questions more? Ramakrishna, please go ahead, sir.
Sir, this is regarding the cutoff date given by the Supreme Court regarding the Coparcenary rights in the property, ancestral property.
Right.
In what circumstances they can have the rights or no rights in the ancestral property?
Even before the amendment in 2005, whatever existed earlier and what is existing today, both will be taken into consideration. And it is retrospective, means even prior to the amendment, prospective, even after the amendment, it has got application. So the question of being only prospective doesn't arise. That's what the judgment in Vinita Sharma's case.
This amendment itself has given a wider scope for the litigation.
Exactly, not wider scope, but it's so far so good for us, sir.
New litigation.
Regarding oral partition with respect to cutoff date and cutoff date, sir?
Even oral or written, sir, the same law, the same rules apply.
Thank you, sir.
Vinita Sharma's case is a revolutionary judgment which is given by the Supreme Court. It's a full bench judgment.
Please go ahead, sir.
Sir, good evening, sir.
Good evening.
So we have understood what are the rights of both the male child and girl child.
Yeah.
In the law, whether there are any laws which define the responsibilities also with respect to the parents, or
sir, that is, you have got aged parents maintenance acts separately, and even now under the BNSS, The aged parents are also included in section 125 now, corresponding to 145, where they say aged parents also will have to be maintained. So that is a drastic amendment that has been brought as far as the law of maintenance is concerned under section 145 of the BNSS.
So both have equal
Yes.
duties.
Yes. You can pick and choose among any children and then ask for maintenance.
Okay. The choice of the parents.
Exactly. They call it as a Senior Citizens Maintenance Act. Separate enactment also is there.
Thank you, sir.
Right.
Yes, Mr. Tiwari.
Hello, sir. Good evening.
Good evening.
No doubt, sir. No doubt.
Mr. Saurabh.
Also regarding this Stridhana and Binami versus, sir.
Nataraj sir, we'll get back to you. Please wait. Mr. Tiwari is asking some question.
Just a minute.
Okay.
Yes, Mr.
Sir, what are
Tiwari.
the rights of unborn child?
Yes.
Rights of unborn child. Sir.
As far as an unborn child is concerned, if she is in the he or she is in the womb of the mother, as soon as it is conceived, coming into existence in this world, the right which that unborn child gets is absolute right, but the enjoyment is postponed till the attainment of age of majority.
Before the
Sir,
child is born,
Sir, good evening, sir.
Good evening.
Venkatesh Garu, please hold. Tiwari ji, please go ahead with the question.
at the time the child is in womb, can a property be in the name of unborn child?
No, sir. Actually, according to section Transfer of Property Act, if I'm correct, it's section 10 or 11, which says first it should be transferred in favor of a living person living on the date of transfer, and the ultimate interest can be given to an unborn child, and the unborn child is, as soon as the unborn child comes into existence, the interest which is devoured by the unborn child is an absolute interest, but it is postponed till the attainment of age of majority. But it cannot be made directly in favor of an unborn child.
Okay, sir. Thank you. Clarified.
All right, Mr. Venkatesh Garu, please go ahead with the question, sir.
Sir, good evening, sir.
Good evening.
Sir, please explain Kamala Negi. Can you say citation, sir?
1 minute, sir. 1 minute, sir.
Citation, please.
Yes, sir. 1 minute, sir.
Kamala Negi, some I didn't understand.
Yes, sir. Just a minute.
Please.
Just a minute. As far as Kamala Negi is concerned, case is concerned,
Spelling, sir. I'm asking spelling.
Kamala, KMLA.
Sir?
KMLA.
Kamala?
Kamala Neti. NETI. TI versus LAO. That is Land Acquisition Officer.
Sir. Year.
Year is
2020.
2023 bracket 3 SCC 528.
520?
8.
520.
528.
Thank you, sir. Thank you.
I think you understood the facts there. Even a tribal woman cannot be discriminated. She also gets an equal right because of the amendment.
According to sir, yes, sir. Here my doubt is tribal rights are separate, sir.
They are separate, sir, but under the Hindu Succession Act also their rights are recognized.
Yeah.
All right. Mr. Durga Prasad.
Thank you, sir.
You're welcome.
Yes, sir. Good evening. Thank you, sir.
Good
Thanks
evening.
for giving the opportunity. I wanted to know, sir, 12 years period for limitation in partition. After dying the owner of that property?
After the death of the deceased, the partition opens. From that time, it is 12 years.
Okay, sir. Thank you. Thanks a lot, sir.
Mr. Nataraj, please go ahead with your question. Mr. Nataraj,
Sir.
please go ahead with the question.
Yeah, regarding the succession, Stridhana and Binami versus, is there no, sir? In their case, any citations?
Sir, there is no citation, sir, because I'm not dealing with Benami Transfers Prohibition Act. If you want me, I only that section 3. If you see section 3 of the Benami Properties Prohibition of Transfers Act, and here succession is concerned, Benami it's a separate enactment by itself. That is usually filed by the husband against the wife.
But again, you will have a taxation problems.
You'll have to prove the source of consideration.
Everything will lie on yourself only when you file.
And sir, you said that when one co-partner want to gift only his share of the property, in that case, why he need to take the consent of the other co-partners also, sir?
The partition has not taken place as it.
If the partition doesn't happen, what will we do, sir?
That preemptive right should be given to all the co-partners.
You can file it as illegal as also.
Okay. So instead of gift, he may write the will for his share.
Yeah, that he can do.
Thank you.
Mr. Srinivas.
Sir,
good evening, sir.
Sir, 1 minute, sir. One more judgment I forgot to cite, sir. Actually, that is a case of course, it's a case from Kerala. Kottukandi, that is, I'll give you the citation, 2022 SC 737. 2022 SC 737. That is Kottukandi Irathil Krishnan versus Kottukandi Irathil Valsam. That is, here, children of living partners also entitled to a share. Suppose, let us say, there is no marriage and they are living together. Now, living marriages are permitted. That is, then if any offsprings are there as far as that living relationship is concerned, they also get equal rights for sharing. That is the judgment of the Supreme Court rendered in 2022, sir.
All right. Mr. Srinivas, please go ahead with the question.
Sir, thank you, sir. Thank you, sir.
Yes.
Sir, could you kindly elucidate on difference between coparcenary property and ancestral property? I'm a little bit confused.
As far as ancestral is concerned, which is coming from forefathers, number one. Coparcenary means where they belong to the same family and the same generation, which is from generation to generation. They come from common grandfather or grandfather's brother or so on and so forth. They belong to the same dynasty or the same descendants. And that property which is in the name of the family is called coparcenary property. Coparceners means as a matter of right, as a matter of birth, you get a right in respect of your because you are a member of the family, you are a coparcener. Ancestral means which is coming from ancestors, which is coming from forefathers. That is called ancestral property. Coparcenary, there's not much of difference between that. Coparcenary means where you belong to that person, a particular generation, where you belong to that particular ancestor, and from your ancestor it has come to your other person, from other person it has come, and from PD to PD they call it in Hindi. That is ఒకటే ఫ్యామిలీలో ఒక దీని నుంచి వంశవృక్షం నుంచి అందరికి వచ్చేది అది ancestral, ఇది coparcenary అంటారు. I'm making myself clear to you, please. There is not much of difference, sir.
Thank you, sir.
Thank you very much. Any more questions? All right.
Hello, sir. Good evening, sir.
Good evening.
Hello, good evening, sir.
Good evening, sir.
Sir, please explain the difference between prospective and retrospective.
Sir, prospective means from the day of amendment, it is called prospective. Retrospective means even prior to the amendment, it means retrospective. దానికి ముందు కూడా అది retrospective అంటారు. దానికి తర్వాత అనేది prospective అంటారు.
Okay, thank you.
Any more questions?
Thank you. Sir, Durga Prasad here.
Yeah, Mr. Durga.
Sir, I wanted to know the permission to be taken for transfer the right or selling the shares. Can you tell the section?
1 minute, sir. That is, as far as that is concerned, that is right of preemption, which is recognized by section 22.
Okay, sir. Thanks a lot, sir.
Thank you. Let's conclude for the day today. Thank you very much.
Thank you.
Thank you. And you can have the look in the YouTube, Dharma Legal. You can have a review on it. Thank you much.
Can you?
Yes? iyenagar.